wiser to shout. Thank you, everyone. I'm now going to hand over to Honour Judge Gordon Saker.
I just need to tell you all that the lunch is for networking. You can't be chatting over coffee and networking. I think you all need to know that. I don't know how many of you read the Times, but there was a feature on it this morning, on an On This Day feature 100 years ago, which I read with some interest, because a solicitor was prosecuted for assaulting a barrister. And apparently what this solicitor did, he tried to give this barrister work. The barrister didn't want to work for this solicitor anymore. So I hope there's nobody here we've got these problems with. And when the solicitor went round to the chambers to deliver a brief at 4 o'clock, the barrister went up to him and said, "I will have nothing to do with you. I will not speak to you." And so the solicitor punched him in the face. So I just want to suggest to you all that when you're having your networking lunch, do be very careful that you don't upset anybody, because it could be extremely dangerous around here. For those of you I don't know, I'm Liza Gordon-Saker, I'm the DFJ. I couldn't come to this conference last year, so I entrusted my slot to Judge Chowdhury. Now, some people who were here tell me that he rather departed from the script, so this year I thought I'd better come in person so I could just keep an eye on him. I don't have very much, you'll be pleased to know, that I want to say by way of moans, but I'll come up with one or two. I really, first of all, want to thank lots of people, because I think this is a fantastic day that gets organised for us by the local Family Justice Board. Deborah and the team put together some really good speakers. Elaine managed to get the venue, and there were obviously some negotiations going on behind the scenes about providing the venue and paying for it, which I never got the full details of. And obviously we've got some really good speakers. So I want to thank everybody involved on your behalf. And I have to say, I think that talk from Michael at CFAB was particularly useful, because so many cases we need overseas assessments, and to know the full range of what CFAB can provide was really helpful. You've got the networking lunch, which is being sponsored, which is very helpful and very nice, so thank you to Fenners for that. And you've got the team from MEWA who deal with experts are here, so if you want to chat to them, they'll be around as well, and they're very useful and very interesting to talk to. So those are all the things you can do in that hour networking. What I do not want to see at lunchtime is everybody talking to their friends. Everybody is expected to make one new friend over lunch, okay? And I'm going to quiz you on it later. On the more serious topics, I want to give you just a few updates on what's going on at the moment. One is on the good news front from the judge's point of view. You know we have a shortage of judges, but District Judge Evans, who some of you will know because he does private law and money, is now getting a public law ticket. So we will have a public law district judge in each court. Jason Slane, who's here, who I'm sure you know, in Cambridge, Franklin Evans in Peterborough, which will help the team, and that's a good start. You're going to get a talk in a minute from Abigail about police disclosure, and those of you who were here last year will know that we got a very good talk from Janine and her team. And Abigail's going to give you some tips about what to ask for and what's available. I just wanted to give a slight add-on to what you were told last year, and that is that one thing always to remember is you've got to ask for all the names and addresses of everybody you want information about, because if you just say, provide everything unredacted, the police can't do that because they have to follow GDPR and only give you what you ask for. So that's a good tip. For those of you who do private law, have any of you had the awful experience of discovering how expensive it costs? It starts like a Ryanair flight. You can have the basic package for 300. If you want something else, it's 500. If you actually want a seat, it becomes £1,200. So if you want private law police disclosure, do think about what you actually want, because that will affect the cost. And do remember that your own clients can make subject access requests which are free for information about themselves. So that's another way to get the private law disclosure. So I just wanted to remind people of that. On the other positive front, I don't know how many of you managed to attend the court users meeting the other week, but they sort of fell away in COVID and didn't really get going again. We've now restarted them. So there was one in Cambridge a couple of weeks ago. The next one is going to be in Peterborough on the 5th of November. Put that in your diaries. If you're not on the mailing list and want to be added to it, then you can email our manager in Cambridge, and I'll give Deborah the information because I think she's going to send out details later on. And if you've got issues you want to raise at court users meetings, it's done remotely and in person, so do come along and do that. I don't know how many of you were there, but one of the matters raised at that was whether we should have a protocol involving everybody, lawyers, judges, groups like CAFCAS, etc., local authorities, about information sharing about potentially violent perpetrators, because this is a problem that, as we all know, is getting worse and worse. And Judge Perusco and Milton Keynes put together a protocol for information sharing. He's happy to share it with us and for us to put our own in place that works for us. So if you all think that you like that idea, then let me know, and tell me today or email me. And if everybody does think it's a good idea, then I'll follow it up and try to do that. Some of you who are into the internet may know that Cumbria has a brilliant website with lots of information about what goes on in Cumbria and about courts and local protocols. And I've been talking to the DFJs in Bedfordshire and Hertfordshire as to whether or not we could have one for us with lots of information on. So again, if you feel like it, have a look at the Cumbria one. If you like the idea, let me know and I'll try and pursue it. If people think it's a terrible idea, I don't want to spend time pursuing it. Those are the positives I wanted to say. I'm sure you want a couple of moans, don't you? I'm not hearing much enthusiasm for those. Can I say that here today, we've got, obviously, local authority lawyers, we've got several judges, we've got lots of solicitors who represent children, who represent parents, who represent guardians, and we've got CAFCAS guardians here, we've got magistrates, we've got legal advisors. And while we're all here, we're also looking at urgent cases that come in. And there is nothing worse for all of us than discovering there's an urgent case come in that has to be heard today, but actually could have come in 2 or 3 days ago. So my plea, which I make regularly, is if you know a case is going to need a hearing, please give everybody 2 or 3 days' notice, so that instead of getting on with doing the allocation, fitting in a hearing, trying to find somebody to deal with it, we could spend our time eating chocolate cake here. And those are important considerations. So that's my one plea and my mum moan. My other moan, and I'm sorry, this is aimed at local authorities, it is the number of times judges have been told lately that things are delayed because of quality assurance or somebody checking documents. My very sarcastic reply is usually to get the red book and ask them where I will find that in the Children Act. You have to work through the timetable that works for the children and comply with the law. Internal processes within firms, within local authorities, within CAFCAS, us within the courts, the actual law and the procedure and the rules have to take priority. So those are my moans. It's making sure we all work together for children. I know that you all work very hard, and I know that we have shortages of lawyers, we have shortages of social workers, we have shortages of judges. But that reason is why we need to work together to give everybody enough time to be sorted out and so that we can give cases the proper amount of time, not keep squashing them in. So that's my one moan. On the other note, of course, I can tell you all that we are aware of the problems with the Legal Aid Agency, and so if you get that problems over your funding at the moment and explain that to us, we will understand, because I know that's a problem and some workarounds are being devised. I think that is all I wanted to say by way of a few things to update. I'm just checking through my list, but I think I've covered everything. I'm here all day. Do come and chat to me. We've got lots of the other judges here. Judge Slaney is here, Judge Waring, Judge Spinks, Judge Chowdhury. Do come and chat with us about anything you want. But most importantly, also chat to each other and enjoy the day in what is a really lovely venue. So thank you all very much.
Thank you. And now Abigail Robinson, who's criminal practitioner at Fenners, is going to come and try and give us some pointers on what we might want to ask for when we're looking at police disclosure. Thank you.
Hello, I am a criminal barrister, and so what I'm hoping I can do is tell you what we have in criminal proceedings. I'm not going to talk to you about how you go and get it, because quite frankly, I don't know. But what I do know is what we have. And so I'm hoping that by taking you through the documents we have in crime, when it comes to you deciding what you need disclosure of, you have an idea of what we actually have, because we have loads of stuff that you probably never have either heard of or seen unless you go right into the fine tooth of it. Now, I anticipate I'll miss a load of documents, but I've tried to prioritise the things that, to me, having done a little bit of family a few years ago, may be helpful. But what I'm going to start with is talking to you about criminal proceedings and how cases make their ways through the courts. Now, I'm hoping that this is somewhat useful to at least somebody here who's never done crime and has no idea. Because one of the things that I am often asked is, this is an acronym, what is a PTPH, what stage are we at, how do I know where this criminal case is at in the system? And so I hope this is useful. I have loads of notes at the bottom of all of these slides. Some of them I will skip over. I anticipate they're going to be sent out anyway, so hopefully if I've missed something, it's in the notes section on the slides. This is quite a helpful diagram which tells you how cases make their way through the criminal courts, starting with when the offence is first committed, the allegation made, through the investigation, through somebody being interviewed, a charging decision being made, and then into the courts. Now, all cases start in magistrates' court, then they either stay in a magistrates' court or they're sent up to the Crown Court. The first hearing in the Crown Court is your plea and trial preparation hearing, so your PTPH. Then you go through trial, through sentence. Now, just practical notes for those of you who don't know. Cambridge Crown Court is Cambridge, Peterborough and Huntingdon. So the fact that your client has said that it is their trial is at Peterborough, it's at Cambridge, it's just sitting at Peterborough. Norwich, for anybody who's interested, also sits at King's Lynn, and some West Suffolk cases, so Newmarket cases, will now be heard in Cambridge. I'm not going to go in complete detail through all of that, but there is notes on the slide for anybody who has any specific points to raise about that. In terms of the position on bail, if you're told somebody is on police bail, that typically means that a charging decision hasn't been made, which means that it's no more than an allegation at that point in time. I should raise pre-charge bail is a matter for the police. They decide what conditions they want to impose. Post-charge, the CPS will have more of an impact on. Breach of pre-charge bail is not a criminal offence. Breach of post-charge bail is a criminal offence. Once it gets to court, it will move over to court bail, and the determination of whether somebody is on bail or in custody, there is a right to bail. Everybody has a right to bail when they first go to court, and there are a number of exceptions which I've outlined on the slides as to when bail can be objected to. The exception to all of that is murder, when cases are a little bit more complicated. The other at this stage thing I wanted to raise is restraining orders. There's two types of restraining orders in crime. There's restraining orders on conviction, and there's restraining orders on acquittal. Restraining orders on conviction, the authorities I've put up on there for you, and that is an order made by the court at the conclusion of criminal proceedings, typically. There are, however, occasions where usually part of a compromise, if we're being honest, typically in the magistrate's court, there is going to be a restraining order on acquittal or a non-conviction restraining order. It has exactly the same legal effect. Now, one of the things I did want to raise is that the Court of Appeal in crime has been very clear. We can't impose a restraining order on somebody who doesn't want one. And so if you are looking at a case, wondering why on earth this went through the courts and there's no restraining order, Court of Appeal, very clear, you can't have a restraining order on somebody who doesn't want one. It's not the court's job to make their life decisions for them, regardless of how that life decision may look to an outsider. There are some other orders which are also made by the courts. You've got notification requirements. Those are in sexual offences. They apply automatically. A list of things that will be set out. They must comply with them. They must go and register all of that. Sexual harm prevention orders. Those are slightly different. They're made by a court, and the terms are usually fine-tuned to whatever the risk in the case is. You've got sexual risk orders, you've got stalking protection orders, and domestic violence protection notices and orders. I've summarised those a little bit there. Breach of any of those is a criminal offence. The authorities are there in case it comes up in a case and you need a point of reference. The main question I'm usually asked about the proceedings is, well, they've been charged, how long is it until their criminal trial? It's very easy in a custody time limit case, because I can tell you that it's probably either within 56 days or 182 days of the first appearance in the magistrate's court. Usually. I say that because it's usually about within a month of that, typically. If they're on bail, the answer is it depends. It could be, I'm putting it this way, in Cambridge at the moment, somebody at a PTPH today with a 4-day trial that needs listed is probably looking in October of next year. That's good, if I'm being honest. That is really good. Locally, our times are much better. Our backlog is much smaller. You go to other court centres, 2-day cases I know are being listed into 2027 and 2028 for a 2-day bail case. I've put here some resources that you may find useful as and when things come up. But I wanted to move on to the documents that we have, starting with the preliminary documents. Your custody records. These are the document that's created by the police. The moment that a individual accused is in the police station, the custody record starts to run, and it starts to run with everything being noted. So this includes them being told of their rights, what they had on their person when they were arrested. It includes whether they saw anybody to be notified of their arrest, including who. But what you may also find most useful is that if there are concerns about whether somebody was under the influence or intoxicated at the time of the offence, it will likely state whether that is the case when they reach custody. Now, that is because it will determine whether they are interviewed straight away, or it will determine whether there is a delay in interviewing them because they're not fit. And so in the notes section on this, I've put some occasions when you might think that a custody record might actually be quite helpful. The large one is if there's concerns about intoxication at the time, but there's also if they assert that they are injured. Any defendant injured, any injuries must be recorded in the custody record. Any access to healthcare professionals must be recorded in the custody record. So anything that could be relevant in those few hours after somebody is arrested should be in the custody record. And everything is time-stamped as well. Your crime report, which I'm sure many of you have seen, runs from the moment at which something is alleged through to the point at which a decision is made and whether it's NFA'd, so no further action, or whether it's a charging decision. It should include a summary of the allegations. It should include what the initial steps are, whether there's any house-to-house inquiries, what the neighbours may have said, and things like that. It will often, in domestic cases, note whether there has been any previous crimes reported involving these persons. That's usually, even for us, the only time we'll find out that there have been 5 other allegations made previously involving case files. So the crime report, it contains an awful lot of information. One of the most important things that it contains is if there has been a decision to not proceed with a case, if it's been NFA'd, it should, and I'm always going to use the word should because they are of varying standards, it should tell you why it's been NFA'd. That means it should be whether the victim doesn't wish to engage, whether there's lack of evidence, any of those reasons. 999 calls and storm reports. So the storm report is the written log that is typed by the person on the 999 call. It's their live record of what is being alleged, what is being said to happen. All 999 calls are recorded. If a case has reached the Crown Court, the likelihood is it has been put on a link and you can ask for disclosure of the link, which will give you the audio, or you can ask for the storm report. If it's a case in the Magistrates' Court, I can't guarantee it's been put on a link because there's less material is presented ready to go in the Magistrates' Court. You've also got the DASH and the DARA forms. I think DARA is the new way of saying it. It's the same form, and in fact, I've put links there so that you can actually see what the form looks like. Whenever there's an allegation of domestic abuse, the complainant will be given the option to sit and complete a DARA form. It includes any previous instances. So if there are concerns that this has only been reported today, but there may have been offences previously or allegations previously, then that should be included. These days, it includes a set series of questions, including, have they ever assaulted you? Have they ever strangled you? Is there any financial abuse going on in the relationship? Your notice of criminal charges, which are there, this is the initial notification, and I must emphasise that charges change at Magistrates' Court, but this is the initial, what they are summoned with and what they are originally charged with. In the Crown Court, that's replaced by your indictment. Your indictment will tell you what they're charged with. That doesn't mean that's what they're convicted of. Those are two different things, and the certificate of conviction will tell you what they've been convicted of, but the indictment on an ongoing case particularly will tell you what the case is. The most frequently thing that you should probably be asking for in a case that you know has reached court is the MG5, which is the case summary. It's drafted by the police. And I know there are some police officers here, so I'm going to say this as nicely as I can. They are of varying standards. Some MG5s are excellent. They are really very fantastic. They are so useful. They are so accurate. Some MG5s are less so, and you have to adopt a slight degree of caution. It's an initial point, in my view, to consider, and then it may help moving forward. It's not conclusive of everything. But what it does usefully set out is everything in one document. So you've got the summary of the offence, you've got a summary of what the defendant has said in interview. That will usually include any pre-prepared statement being typed up. And then you've got any evidence there is supporting it, and any applications on conviction. I'm conscious I'm going over time slightly, so I'm going to skip to the most important documents that I think, or things that are less common sense. Interviews. Where a defendant is interviewed, if the case makes it to the Crown Court, there will always be a transcript of that interview. It's called the ROTI, R-O-T-I. It will always be transcribed or summarised. If it's in the Magistrates' Court, it is not transcribed or summarised unless defence solicitors have paid for it. The only way you can get the interviews to ask the police for the DVD, otherwise the summary in the MG5 is what was said. If a defendant answers no comment, there may be what's called a pre-prepared statement. Those should all, I would say that you probably, if you're asking for an interview, you want to put / any pre-prepared statement that was advanced in the interview. Witness statements, you should all know, I'm pretty sure they're the same in every area of law. ABEs, however, I know I was specifically asked to mention. This is an interview that the police conduct with the complainant or a witness. It can be anyone. And it effectively stands in place of a witness statement. There are no general rules as to when an ABE will be completed versus when it won't be. It varies very much on the facts. There are certain occasions when you can expect there to have been an ABE recording, and it's a recorded interview. Where the witness is a child, there will almost invariably be an ABE. Where the witness is particularly vulnerable, sexual offences, and most recently, and in my view, helpfully from a criminal practitioner's point of view, in cases involving coercive and controlling behaviour. In those categories, in my experience, there will almost invariably have been a pre-recorded interview. That will usually stand as the evidence in chief in a trial. The only thing I will raise is that just because there's an ABE doesn't mean that there wasn't a witness statement as well as. Sometimes things come up either before or afterwards, and there's a witness statement done as well. This is the next thing that I did want to raise because it's a little bit complicated and the law surrounding it and its practice is very new. You've probably all heard you can pre-record your cross-examination in criminal cases now, which means that cross-examination of particularly vulnerable people is done in a courtroom without a jury present. It applies in very specific cases, and on the next two slides, I've put the test in for vulnerable witnesses and intimidated witnesses. The short version of this is if it is a person under 16 at the time that at the time the application is made, they will probably be a pre-recorded cross-examination. That means it's done before the trial, not at the same time of the trial. Body-worn video is also something you may want to consider. Any initial account provided to a police officer will likely be captured or should be captured on body-worn video. There's also then, we have streamlined forensic reports. They're a summary of what the streamlined forensic evidence is, so whether that be medical, DNA, or fingerprints or anything like that. It's not the specific law surrounding it. I've summarised it in the notes section. It's not evidence in and of itself. It must be agreed to be evidence, but for your references in family proceedings, it's a helpful indication of what the evidence was. The final things I'm going to mention, and as I say, I've got still another 10 slides on here, so anybody who finds it useful can have a look on the slides. The defence case statement you will likely want to seek disclosure of. That is the document that summarises what the defendant's defence being raised is. If it's an active, ongoing case, or even if it went to trial and you want to know what the defendant said, well, the defence case statement is generally the place to look. This is their account that gives rise to the prosecution's duty on disclosure, and so it is a very important document. You can see there's a whole initial part that goes to it, because if you don't mention in your defence statement and you do rely on a trial, likelihood is there'll be an adverse inference. So it should properly summarise what the case is. And basis of pleas. I'm quite often asked in the robing room, if somebody's been sentenced, what have they been sentenced for? What facts have they been sentenced for? There's a few things you want to, if that's an issue and you're looking at police disclosure, you're going to want to ask for any basis of plea. This is where the defendant says, yes, I'm guilty, but I'm guilty on these facts. You'll also want any prosecution response to a basis of plea. I know in a child abduction case recently, those were the two main documents that were needed from the criminal proceedings in the family proceedings. That is one part. You may also want any prosecution sentencing note. That should properly summarise what the offence is for the judge in deciding sentence. And the final thing I'll raise, because I'm going over on time, is criminal proceedings in the Crown Court are all recorded. Everything is recorded. And so you can, in theory, ask for the transcript of the judge's sentencing remarks. You will need to know when it was said, when sentence was passed, and that may be something you need disclosure of to find out. But that may be, if there is a real issue surrounding what somebody says they were sentenced for and how that sentence was reached, that would be probably the best place to start. In the remaining documents are summarised in this slide for those who want them. There's pre-sentence reports, where they come from and who they're drafted by, as well as some other court orders. I think, given time, I'll stop there, but there's one last thing which I have been allowed to just flag up, and that is anybody called to the bar who wants to come to the Cambridge and Peterborough Bar Mess dinner. I am the secretary, and so I am trying to encourage everybody to come. We have our Honour Lindsay Davies doing a post-dinner speech, and we are very much trying to get as many non-criminal practitioners as we can to come. It's at Christ College. It's beautiful. We will be outside on the lawn to begin with and then have dinner. So I hope that's helpful. Thank you.
Well, thank you very much, Abby. That was a really helpful summary, and much fuller notes are going to come out as well. And now, Dr. Ibrahim Jallo, consultant neurosurgeon at Addenbrooke, someone who's known to some of us from our cases, is going to come and talk to us about inflicted head injuries.
Okay, thank you very much. Thanks so much. Good afternoon, everybody. It's a real honour, real pleasure to be in a room full of lawyers. It's a little bit intimidating, I must say. So I'm Ibrahim. I'm a consultant neurosurgeon just down the road in Cambridge. So I'm a paediatric neurosurgeon, but I also have an academic interest in traumatic brain injury. I also have an interest in neurorehabilitation, so I lead a rehabilitation for children who've had brain injuries. So just very briefly this afternoon, I'm going to give a brief outline on traumatic brain injury. So just the general pathophysiology and how we manage it, the paradigms for that. And then obviously the focus for today is on infant TBI. And then just going to discuss some of the challenges that I face as an expert, compared to how being a clinician is really. So initially, in terms of TBI pathophysiology, so the first thing to note is that children are not like young adults. There are specifics about the skull, their neurobiology. So for instance, children generally have quite big heads and weak neck muscles, and that makes them quite prone to head injury, and particularly shaking head injuries, as we're all too familiar with. Particularly younger infants tend to have a pliable skull, and there are different characteristics that might make a younger infant fracture their skull compared to an older infant. And there are different features of the neurobiology that impact the response to a head injury in these different age groups. So traumatic brain injury in general is a very heterogeneous disorder. There's not one size fits all. So we have various ways clinically of classifying it. So that can be based on the mechanism. Is it an open or closed injury? We're pretty fortunate. We don't see many open injuries in terms of gunshots in the UK, although I have seen a few. And then in terms of closed injury, which is the majority of head injuries that we treat, they're either high energy, high velocity, so for instance, car accidents, versus low velocity, so elderly people that have falls and assaults. And then there's the specifics of infant traumatic brain injury, and particularly non-accidental injury, which sometimes is repetitive. It's a heterogeneous disorder. We can also divide it based on the lesions that we see, the morphology, so what's happened to the head, what we can see on the scan. So that those can be skull fractures that can affect the main vault, so the top bit of the head, or they can affect the skull base, versus intracranial bleeds, intracranial hemorrhage. And sometimes those are more diffuse injuries, sometimes those are a more focal injury. And those are some of the terms that you might have come across. So hematoma being a bleed within the brain substance, a contusion being a bruise of the brain substance, and then various bleeds that we see within the cranium. The other big way that we classify head injuries, just in general, is the GCS, the Glasgow Coma Score. And if you deal with any head injury cases, you'll probably come across this term in the medical notes. And it's a way of dividing head injuries into mild, moderate, or severe clinically. And the relevance of that is that it has implications for how these children do and also guides how we treat them. The GCS, you guys are all mostly GCS 15, maybe GCS 14 if you're starting to nod off, but essentially it's the composite score of eye-opening. If you're opening spontaneously, you get 4. Your best verbal response, confused people, will be a GCS of 14, for instance, and then your best motor response. So in terms of the management of head injury, there's obviously nothing that we can do about the children that go, I've had children that climb abandoned warehouses, children that go car surfing. E-scooters is a big cause of accidents in children recently, and probably the worst of all is horse riding, to be honest. So we can't do anything about the primary injury, so it's all about preventing what happens next, the secondary injury. The secondary injury features brain swelling, which causes raised cranial pressure. That interferes with the normal delivery of oxygen and nutrients to the brain. That's compounded if there's any systemic hypoxia and hypertension. So somebody that's had a car accident might have a chest injury, they might be bleeding. That compounds any secondary injury to the brain, and so on. And so the management of head injury is all aimed really at preventing this secondary injury. And the problem with secondary injury is that all these mechanisms amplify, and you end up with vicious circles of brain injury mechanisms that, if left unchecked, ultimately lead to brain death, worse outcomes, neurological harm. So that's the kind of pathophysiology of brain injury in a nutshell, and the general paradigm for how we manage it. I think more relevant to you guys is some of the features of infant TBI that we treat. And obviously not all infant TBI is non-accidental injury, but often that's what we're trying to exclude. Skull fractures first. So skull fractures are actually quite common after accidental falls. And I've just put, this is from a paper that was studying how long it takes a skull fracture to heal on imaging. And it's just an illustration of roughly about 70% of skull fractures that we see are actually caused accidentally. I mean, put your hand up if you've ever, fractured your own child's skull, but it happens quite a lot of the time. Unfortunately, it's usually the poor dads that have left the kid alone on the change table, and they feel terrible. So the typical response of an infant that's fractured their skull, it's a pretty benign clinical response. So initially, they might look a little bit stunned. They don't always even cry. If they do cry or scream, it's usually for a few minutes, and they can be comforted by a cuddle or a feed. And often, that's the only symptoms that they have. I mean, sometimes they have a mild concussion, so they might have a couple of vomits on the way to the hospital. But generally, they remain quite well. So people are often surprised that although clearly it takes a bit of force to fracture the skull, the clinical consequence of that is actually mild. They will develop a scalp lump, and that's sometimes relevant in terms of when we try and age these injuries. And typically, swelling, a scalp lump will develop after, within an hour or two. Sometimes it's difficult to notice depending on the thickness of the hair. And it's not impossible for scalp swelling associated with the scalp fracture to be missed. But typically it comes up pretty quickly and will generally last for about a week or two. I mean, sometimes we hear particularly radiology experts try and correlate the complexity of the fracture with the likelihood of abuse. And that's difficult because there are so many factors that will influence how a skull fractures. Generally, the younger the infant, the more likely they are to have a complex skull fracture based on the constitutional characteristics of the bone. By complex skull fracture, what I mean is that most skull fracture are just a linear crack in one bone, usually the parietal bone. A complex fracture is when it has lots of branches, it involves more than one bone, goes across the natural sutures in the bone. But the skull, often explained, is a little bit like an eggshell. So, actually you crack it, and it is relatively easy, based on the characteristics of the skull, to get propagation of that fracture. So the complexity of a fracture is not necessarily a good correlate in terms of abuse or level of force. There are many factors that influence whether a skull will fracture when an infant falls. So that includes the surface that they land on. Is it a carpet? Is it a hard surface? It obviously includes the height of the fall, but it includes lots of other biomechanical features as well, such as the motion of the infant as they fall, the position of the body, the position of the head as they land. And so this has been captured experimentally, trying to work out the threshold heights and the surfaces under which you can fracture the skull. This is based on cadaveric studies, some animal studies, and then computer modeling. And essentially, you show experimentally that really you can, in some occasions, on a rare occasion, fracture a skull from a height fall of low as 0.3 meters, so 1 foot. In the real world, what we see is that it's pretty rare. You don't really see skull fractures below a height of 0.5 meters, so half a meter. Again, this just illustrates, so this is 450 children that were assessed in A&E with a head injury after a fall, and 40 or so of them have got a skull fracture or an intracranial hemorrhage. So these are non-abuse injuries, these are all falls. So again, it just shows you that the incidence of skull fractures and intracranial hemorrhage after accidental falls at home is higher than a lot of people think. In terms of aging the fracture, there are features that help us. So CT imaging is the cornerstone of head injury imaging. Blood on a CT, so fresh blood on a CT looks white. And in general, although this is not an exact science, if there's fresh white blood on a CT, the bleeding is less than 11 days old. A lot of skull fractures will be associated with a little bit of bleeding just on the inside of the skull, so an acute subdural hematoma. And so that can be useful. If it's fresh white, it indicates that the skull fracture was likely caused within 10 or 11 days. And then, as I've mentioned, most, not absolutely all, 100%, but most skull fractures will be associated with at least some degree of scalp swelling, that even if it's not obviously, if it's not obvious clinically, the parents or the doctors don't notice it, you can see it on the CT scan, and that will typically be present for a couple of weeks. So that's another way that we help age these skull fractures. So sometimes we're asked about, could this skull fracture extend from birth? There's been a few relatively recent, so within the last 10 to 20 years, large population-based studies to work out the incident rate of birth-related skull fractures. And it equates to 0.2 to 0.6 per 1,000 births. That sounds pretty rare. I mean, if you do the maths, that's 1 in 16,000. There's about 600,000 live births in England, Wales, and Scotland every year. So that's roughly 40 skull fractures from birth in a year in the UK. There are 19 paediatric neurosurgery centres in the UK, so we'll probably hear about all of these. So on average, I should expect to hear about 2 birth-related skull fractures per year. So although the numbers look rare, these do happen. And I'll come on to the issues of rarity later on. It's not surprising that birth occasionally results in skull fracture, and these are births that don't necessarily use forceps or von Schoo's suction delivery. But this is a fascinating study. It's amazing that they did this, where they placed mothers that were in the process of labour, given birth, in an MRI scanner, and got these phenomenal pictures that show what happens to the baby's head as it's being born, and they measure the degree of deformation, and there's a huge degree of deformation, and so it's actually not surprising that occasionally birth, results in skull fractures and other injuries. Typically, if there was a skull fracture at birth, then we see it as scalp swelling or cephalohematoma, and occasionally a baby that has poor APGAR scores, so a baby that's born well because of a significant head injury caused at birth. So skull fracture is a big thing. Moving on to subdural bleeds, subdural collections. This is the other kind of feature, and if you know about the triad or the historical triad of abusive head trauma, so subdural bleeds, encephalopathy and retinal hemorrhages, obviously subdural bleeds is something that we look at quite a lot. The first distinction is based on the distribution in the head. Is it just a focal bleed in one place, or is it multifocal? Is it in both sides of the head, between the hemispheres, in the top and bottom compartments of the head? In general, impact trauma will produce a focal subdural bleed, whereas a shaking type injury, acceleration, deceleration, which represents energy that's distributed throughout the head, will produce subdural bleeds in multiple locations. So on both sides of the head, in between the hemispheres, in both the top and bottom compartments of the head. We see that with shaking injuries. We also see it with the kind of rare high-speed or the rare infant that's involved in a high-speed car accident. So it's a feature of an acceleration, deceleration injury. So it's an important note that really subdural bleeds in infant shaken injuries are really just a surrogate marker of the traumatic energy that has been imposed on the brain. So the bleeds themselves are really tiny. Sometimes, unless you're a trained radiologist or somebody that's used to looking at these scans, you won't necessarily see the subdural bleeding. So it's not the bleeding per se that causes dysfunction or injury to the brain. It's really just a surrogate marker of energy on the brain. And so they're often quite low volume. And so the thing that is the kind of correlate of the neurological dysfunction is the injury to the brain substance. And in the start of the talk, I discussed some of the mechanisms that we experimentally look at and aim to treat when we treat brain injury in general. But it's these changes that are happening at the microscopic level that produce injury to the brain substance, hypoxic ischemic injury, and that's really where the harm comes from. So it's not just bleeding into the subdural space. So the brain is contained, it's surrounded by a leathery membrane that encloses the brain and the spine called the dura. So bleeding, subdural bleeding, is bleeding between that leathery membrane. So that's blood in between that leathery membrane and the brain surface. But it's not just bleeding that we see in infants. We also see cerebrospinal fluid with the bleeding. So we have cerebrospinal fluid that leaks through another membrane that's just adjacent to the brain. So that's a normal membrane, and we all have cerebrospinal fluid that bathes our brain. So that cerebrospinal fluid leaks into the subdural space. So in general, subdural bleeds, subdural collections in infants are a combination of blood and cerebrospinal fluid. And so you'll see various terms such as subdural hematoma, subdural effusion, subdural hematohygroma, and essentially they're all the same thing. They're just collections of fluid that consists of blood and cerebrospinal fluid caused by trauma, so caused by bleeding, rupture of blood vessels, but also by tears in the arachnoid membrane and leakage of cerebrospinal fluid into the subdural space. So the general understanding is that the reason that you get bleeds, or subdural bleeds, so that there are these little veins that span from the outer lining of the dura, span from the dura to the brain surface. And if you shake the brain, if you move the brain relative to the skull and to that leathery membrane that is adherent to the skull, then you stretch and tear these little veins, you get a leak of blood, and that's why you get subdural bleeding. And a kind of, it makes biological sense. A pathological hallmark of that is when you see evidence of damaged bridging veins on scans. And sometimes we see that as what we call thrombosed bridging veins. So when you tear one of these veins, it thromboses, it blocks up. And you can see features of that on a scan. And probably about 10 years ago, that was taken as a pathognomic feature of a shaking. But it kind of makes sense that anything that causes the brain to move relative to the dura and the skull would likely have the same mechanism. So I think nowadays no longer we would necessarily say that bridging vein thrombosis is a hallmark of non-accidental injury, but it might be seen in any kind of injury where there's a degree of movement of the brain relative to the dura, so kind of an impact that causes sufficient inertial acceleration, deceleration of the brain. But this often comes up, so just to mention it to you. In terms of aging the subdurals, I've already talked about how we use CT as the hallmark of imaging in infant brain injury. As I've said, fresh blood, acute bleeding is white on a CT, which means that it is less than 11 days old. And that's the contrast with chronic collections. And sometimes we see infants that have potentially had collections for weeks, if not months. And there are some features that we look for neuroradiologically, so on the imaging, that will give us an indication that this collection has been there for a long time. And first and foremost is if it's a big collection and the child is otherwise relatively well, then to get a big collection and for the child to be relatively well implies that it's built up relatively slowly. And so that's kind of circumstantial evidence that the subdural collection is likely to be long-standing. And we also look for evidence of membranes. Membranes are the healing response to blood. So if you get subdural bleeding, then the healing processes are set up and you sometimes see membranes on a scan. The other thing that we look for clinically is the head circumference. And sometimes that's the only feature of chronic subdural collections building up. Because as I said, if they build up slowly, they often don't cause any clinical compromise in the infant because the head just expands. And we see that as an accelerated growth in head circumference. So I'm often looking through the red book, looking through the medical notes to see what's happened to the head circumference over the last few weeks and months. The oft-quoted papers of Rooks, Whitby, and Looney cited in many, many, many cases. So these were the first groups that characterized the incidence of subdural bleeding associated with birth. And I showed you the skull fracture or the MRI images of a child being born. And again, it's not surprising that the head is subject to quite significant forces being born. These papers established how often subdural bleeds occur in birth, and it's more often than you think. So, 40–50% of newborn infants, if you do an MRI scan, you will find evidence of silent subdural bleeding. So that has to be taken into account when infants present later down the line with subdural bleeds. Could this be from a legacy of their birth, or is this something new? What we know from these papers is that when subdural bleeding occurs at birth, it settles within 4 to 6 weeks. It tends to be at the back of the head. So those are features that can help distinguish between the possibility of a birth-related subdural versus, for instance, non-accidental injury. I suppose the most important aspect of a shaken type injury is the injury to the brain substance. That's what causes the clinical presentation with encephalopathy. We see that radiologically as diffuse swelling of the brain. So that CT scan shows a kind of featureless brain, which is consistent with swelling. So we use this term encephalopathy, which simply means dysfunction of the brain. In an infant, it can be relatively non-specific. So a baby that just doesn't look right, that is irritable, is not handling normal. They might develop seizures. They might have a limp or floppy episode. They might have pauses in their breathing, which we term apnea. So obviously your brain controls your respiratory function, but it also controls your cardiovascular function. So if you have dysfunction of your brain, it can affect your circulation. So babies might appear pale and mottled. And ultimately it progresses to babies ending up in deep coma and dying, unfortunately. It's routine for any baby where non-accidental injury is suspected to have MRI imaging of both the brain and the spine. And that's because in the last 20 years, it's been recognized that there's a high incidence of subdural bleeding found in the spine, up to 40 to 60%. And as far as we know, it's more common to find subdural blood in the spine in non-accidental shaken injury than it is in accidental injury. But the problem is we don't really very often do MRI scans on infants that have isolated head injuries. So the scientific literature doesn't really conclusively say that, again, this is a hallmark of a shaken type injury. The mechanisms of this are not very well understood, and there's often debate as to whether this is blood that has arisen in the spine, and therefore some indication of mechanism, i.e. the body being flexed and extended during a shaking motion, or is this blood that's come from the head? And there's evidence, there's pretty good evidence in adults certainly who have bleeds in the head, who end up with subdural blood in the spine, and there's good kind of pathophysiological mechanisms as to why it's perfectly reasonable why you might see blood in the head that ends up in the spine. Sometimes when we do tumour surgery in kids, we do an MRI scan a few days later and we see that they have blood in the spine. So, probably my opinion is that it's certainly consistent with blood that might have come from the spine, but this is something that often causes some debate. Just finally on the lesions that we see in brain injury in children is just to introduce you to this concept of, or this condition called BESI, or benign expansion of the subarachnoid spaces of infancy. There are various names that are used for it. But it's relevant because it's one of these conditions that is potentially a risk factor for infants developing subdural bleed through everyday trivial trauma. And sometimes it is something that is questioned or picked up on the radiology that's done. It's more common in premature babies, it's more common in boys, and it is associated with some other rare neurodevelopmental disorders such as glutaric aciduria type 1. It's relatively common. We see lots of infants who don't have subdural bleeds, who don't have a head injury, who have expanded CSF spaces. And it essentially just causes a big head, but no other problems. The big head tends to settle. But it is relevant because it probably is a vulnerability factor to causing subdural bleeds in infants. So those are the main, and really it's the main radiological lesions that we see associated with infant TBI and specifically non-accidental injury. And just to finish my talk, I want to talk about some of the challenges in interpreting these findings in the legal sphere, really. So there are inherent differences in terms of being an expert versus being a clinician. So in medical school, all we're taught about is developing a differential diagnosis versus in terms of analysing these cases, it's more about trying to understand the cause, so differential etiology. And they sound kind of similar. The differences are slight, but they are significant. So a differential diagnosis is when you determine the nature of a patient's illnesses for the purposes of diagnosis and treatment, whereas when you're trying to understand the cause, it's really just about that. And they both require basically process of elimination reasoning, but it's different as a doctor because often we don't really care about the cause. We don't know about the cause unless you're an academic researcher, and it's really just about treating and managing the patient. So often with these cases, we're working backwards because we have the lesion, we have the pathology, and we're working backwards to work out what the cause is. And really this just acts as a summary of the lesions that I've discussed and what I would consider a general schema of the likelihood of them being associated with an unaccidental injury versus a trauma. So to the right, multifocal subdural collection, so blood all around the head, in between the hemispheres, associated with a hypoxic ischemic injury, is much more likely to be a non-accidental injury than, for instance, a simple skull fracture. And so we can, devise this kind of general schema, just working backwards based on the lesions, the ones that I've described. But as doctors at medical school, we're taught that to get a diagnosis, 80% of it is with the history. So the history is extremely important. The history is the most important thing in determining what is wrong with your patient. And so we have to listen to the history. Chiefly, the most important one, obviously, is falls. That's often the reason, or that's often what we're trying to tease out as to whether the history of a fall fits with the brain injury that we see. And so we know, and I've discussed this already, falls will readily cause skull fractures. They will readily cause typically small subdural hemorrhages. But very occasionally, very rarely, they will cause multifocal subdural bleeds. And very rarely, very occasionally, they will cause areas of hypoxic ischemic injury. And there are case reports in the literature of infants, children that have fallen, for instance, in hospital under medical supervision on CCTV, who subsequently died from a relatively low height fall. So we have to bear that in mind when we're working forwards from the history. The paper on the right just shows the types of mechanisms that cause these types of injuries in children. So these are all children, infants who've sustained falls, and the black bit are those that have sustained an intracranial bleed or a skull fracture, and these are the ones that have a normal CT. So you can see babies that are dropped by their carer have a relatively high chance of sustaining a skull fracture or a skull fracture, whereas, bouncy chairs, in this particular cohort, no infants sustained any kind of abnormal CT. So understanding this data is helpful to work forwards in terms of analysing the history. The other thing that's important about the history is the history of encephalopathy. So particularly babies who've, the suspicion is that they've had a shaking type injury, they will present with those features of an encephalopathy that I've discussed. So feeling non-specifically not right, irritability, abnormal movements. Often they present with a floppy or limp episode. Often it's quite alarming to the caregivers. Often it's associated with issues with their breathing and prompts a 999 call. And generally, what we believe, and based on some of the physiology, is that the moments after a shaking type injury are probably the most risky in terms of an infant baby suffering a profound loss of consciousness and stopping breathing. So it helps in terms of timing on the basis of the 999 call when a potential shaken injury might have occurred. But sometimes encephalopathy has to be distinguished by a similar kind of dramatic presentation in an infant. So there's this term, BRUI, it's a brief resolved unexplained event, which is the kind of newer term for something called an apparent life-threatening event. And essentially what it is, it's a baby, an infant, that has a brief, less than 1 minute episode of cyanosis or pallor, change in muscle tone, so a short-lived episode of floppiness, where they become unresponsive and they might stop breathing. So it can look very similar to an encephalopathy. The difference being, with an encephalopathy, it's not short-lived. They would likely have ongoing features consistent with a brain injury. And sometimes we're trying to work out whether this episode was the cause of the subdural bleed rather than the other way around. So sometimes the question is, can things like choking or drowning, can that produce a subdural bleed? And probably it can't to any great extent. But again, there's a lot of literature. There's been several studies that have looked at that specific question. So these are all things that we consider. Sometimes a baby might have one of these BRUI episodes, and it's so alarming that the caregiver naturally tries to aggressively resuscitate the infant. And sometimes that's offered as a reason for the brain injury. And I think that just demonstrates the limits of where I can go. It demonstrates the limits of the medical evidence because, whether a caregiver shakes an infant out of panic or out of frustration, I think to me, qualitatively, they might produce the same brain injury. And so therefore, in terms of intent, that's not something for the medical evidence. Often, I'm asked about what is the likelihood of one cause over another. So, for instance, what's the likelihood of multifocal subdural bleeds being caused through an accident or through a shaken-type injury? What's the likelihood that it was caused through this fall? What's the likelihood that it was caused by a shaken injury? And on one hand, on population-level statistics, multifocal subdural bleeding is much more likely to be caused through non-accidental injury. But as I've said, rarely it can be caused through a fall. And so if there is a history of a plausible fall, really we've got these two competing things. One is the veracity of the history, and the other are the population-based statistics. And again, the only expertise I have in interpreting the veracity of the history are the population-based statistics. So there's a degree of circularity, which again is just one of the limits of the medical evidence. And the other challenge is this issue of rarity. I think sometimes rarity is conflated with improbability. And as I've said, I showed you the figures of birth-related skull fractures, and on paper they look really, really rare, and I think some people might equate that to being improbable, but I would still expect to see a couple every year. And it's similar with childhood brain tumours, one of the other things that I treat. The annual incidence is 1 in 25,000, so that is pretty rare. It seems improbable that, you know, that kid's going to have a brain tumour, but I see one a week. So this issue of rarity and improbability don't match up. I'm not sure this is a case that we had of, you know, an improbable, I suppose, accident, but you can see very clearly that it happened. So just to finish off, just to summarise, talked a bit about the pathophysiology of TBI. So infants have large heads, they have weak necks, they're vulnerable to brain injury. Skull fractures are pretty common after accidental falls at home. Multifocal subdural bleeds, really it's a surrogate marker of a diffuse brain injury, but is a hallmark of non-accidental injury. Encephalopathy, so dysfunction of the brain, reflects a multitude of mechanisms that I briefly touched on in the introduction, occurring at the microscopic level in the brain. And ultimately, that results in hypoxic ischemic injury, which is an important determinant of outcome. I talked about some of the challenges of medical expert evidence. We can never say never, you know, rare things we still see. And actually, there's still this issue of the medically unknown, because there are things where, so for instance, I'll give you an example. A couple of weeks ago, we had a 9-year-old that came into hospital with a 24-hour history of acute onset progressive paraparesis. Basically, she'd gone to school one day, had some back pain at school, came home, and by the following morning, couldn't move her legs. Had an MRI scan that showed a spontaneous epidural bleed in her spine, which we evacuated, and there's no cause for it. You know, there's no history of trauma. She's had extensive hematological investigations, but it's well described. We have a term for it in medicine, which is idiopathic. It's just things that we can't explain. They're rare. In this instance, spontaneous epidural bleeds in children are rare, but they do happen for no reason whatsoever. It's just one of those things. I mean, obviously, there are things like that on the screen which, to say that it's medically unknown would be a bit far-fetched. But there are some, you know, sometimes we see scans where, for instance, it's just a very subtle subdural collection. And I think, you know, there's still a place for medically unknown in that differential diagnosis list. So thank you very much. It's been a great honour to share my insights with you. Please let me know if you have any questions.
Thank you very much, Dr. Jallow, for that very interesting and very clear presentation. That brings the morning to an end. Lunch is now going to be provided, and do ask Dr. Jallow any questions over lunch, and do chat to everyone and enjoy yourselves, and see you back here at 2. Thank you.